All right, everybody. I'm back. I got another video here that I'm working on. Good news with the blog. It's continuing I'm continuing to put new posts on there. I have a much normal schedule, like I mentioned this in the last blog post. So I'm catching up now with the blog posts. I'm trying to get the videos there, and then of course I have them transcribed to a podcast in case that makes it easier for you. Some of you are on the go and want to just be able to, go jogging, walk, do the treadmill, whatever it is you like to do, and just listen in. So once I do the videos, just understand the podcast is transcribed basically a day or two later. So you can always go back and check on the blog post and make sure that it's up and ready. Okay. So, what am I going to talk about today? A very important subject, and that is when you file for bankruptcy, what are we going to do with your car? This is an issue with everybody, right? We all want our cars. We all need our cars. Some of us have love affairs with our cars, right? I think I've loved all my cars. They were just not a method of transportation for me. But like one of my clients said, not having a car is like not having a pair of shoes when walking through the streets. Cars are that important. We need it to take the kids to school. We need them to take them to their sports, soccer, football, baseball, etc. Take the girls to piano classes, ballet, whatever it is your family's doing. That car is running back and forth. Without a car, we are at a standstill. We can't do anything. So, of course, what happens with your car in bankruptcy is an issue. And that's what I'm going to talk about today. Now, the first thing you have to figure out is where do you stand? Where do you stand with the equity? Remember, as I have said in many videos and blog posts before, the exemptions is what pretty much controls your case. I know we have to worry about income and everything else, but the exemptions will determine what you get to keep and not get to keep. So, Chapter 7 is known as a liquidation, and that kind of sounds like you're losing everything. But that's not the case because exemptions is what's going to control at the end of the day. Exemptions vary per state. If your state has an exemption of $5,000, then that means the first $5,000 of equity in your car is protected. So we have to look at that. If you have negative equity, not much is going on there, right? If there's anything else, you might have to surrender if you can't afford to pay it back. Maybe at that point you should have filed Chapter 13. And I'm also going to talk about reaffirmation agreements and what that means to your case. Okay. So those are the issues we're going to have to look at when it comes to dealing with your car and how that car is handled. Can you keep it, not keep it? What are the decisions you're going to make? So exemptions. Florida, where I'm at, it's a horrible 1K, isn't it? All right, there we go. A little bit better. Just increased it from $1,000 to $5,000. Now, I'm going to go over how that applies to your case in a couple of minutes when I talk about negative equity. But just understand that's what we have to look at. What is your car worth and what do you owe? That is the equity you have in your car. Now, is that equity protected? Depends on your state. Every state has different exemptions. Once you apply the exemption amount, if there's any money left over, then that's when you have to, see what the next step is going to be with the trustee. Trustee may want it, may not want it, etc. Let's say the trustee wants it because it's a good amount. It's $5,000. What happens? Well, you can buy back that interest from the trustee. So, you're kind of paying for your car again, but you get to keep it. Now, a lot of times clients say, I have to pay this back, $5,000. My next question is, how much debt you getting rid of? 50,000. Sounds like a good deal. I give you 5,000, you get rid of $50,000 in debt. That's always a win-win situation. So change your mindset on that. Don't look at it as I'm buying back my car. I have to pay for this car all over again. Think about taking those steps towards a fresh start and being able to, get rid of all this debt so you can move on with your life, right? Now, let's suppose the equity is an issue, right? The trustee, when you file Chapter 7, at most, they're going to give you 10 to 12 months to pay that back. You can't pay $5,000 in 12 months, 10 months, etc. What are you going to do? You file Chapter 13, and you'll pay that back over 36 to 60 months. So that's an oversimplification of the Chapter 13, but that's how it works. You're just going to pay back the equity over that period of time. The other option is you can just surrender the vehicle. If it's too much equity, Chapter 13, I'll give you a good example. I had a client who the trustee came up with an amount that was ridiculous as to the value of the car. Literally, the car was worth more after 70,000 miles, I don't know how many years, and a car accident. and mechanical issues. And the trustee said the car's worth X amount. I talked it over with my client. He says, I'm not paying back that amount. It doesn't make sense. I can use that amount towards a down payment on a new car, and I'll just get a cosigner. Problem resolved. So sometimes it's just better to surrender the car. So now look at it this way. Rather than give the trustee $5,000, get rid of all your debt, get rid of a car that's been in a car accident, mechanical issues, and now turn around and get a brand new car. So it all depends on the facts of your case and how that could affect you in a good way. Okay. So keep that in mind when it comes to equity issues. Now, if we have negative equity, what happens with your case? Nothing. The trustee's moving on. And here's a quick example. You owe 15,000 and your car's worth 10,000. You have negative 5,000 in equity. Do you really think your trustee wants your car if it has a negative value? No. Cars, good and bad, when you're doing bankruptcy, it's good that they lose their value so quickly because that negative equity is going to protect you. So again, even though we use the term liquidation, a lot of times you're just protected because the reality is cars lose value quickly. And so if you have $5,000 in negative equity, what is the trustee going to do? Take it away from you? They can't sell it. The trustee has to take out 5,000 out of their own pocket to sell it first. Doesn't make any sense. So we move on if there's negative equity. Negative equity is a good thing. You can still turn in your car. Okay, just keep that in mind. That if it's too upside down or the payments are too high, just turn in the car. If you can, and you're in that position, maybe get a co-signer and get another loan in your car and not have to worry about this. Now, what if you are keeping your car? What are we going to do? Well, chances are the bank is going to tell you we need a reaffirmation agreement. And all that is a contract basically saying you're keeping the car. What changes? Nothing. The interest will remain the same. The loan balance will remain the same. If you have 20 months left on your loan, that's going to stay the same. It's pretty much there's no rule, by the way, that says it has to be that way, but that's just the way it is. You can definitely call the bank and say, I owe you 15. What about if we just settle for 10? You can make that phone call. They're not going to talk to you. They're probably going to say not interested. If you want to keep the car, sign a reaffirmation. If you don't want to keep the car, let us know. We'll pick it up and make sure you include it in your bankruptcy. Now, the reaffirmation, we do have to think about the pitfalls here. And this is where you see clients have an issue down the road. I know we cannot predict the future. If we could, we would all be doing something else for a living and working minimal hours, right, and making good money. But that's not the way the world works. So what happens if you sign a reaffirmation agreement? Remember, if you just filed Chapter 7 and it's been approved, you cannot refile for another 8 years. So what happens if unfortunately there's illness, hospital stays, etc., loss of income, loss of a job? How are you going to pay back that car? The answer is, let's suppose you cannot. Now, how does this affect you? Well, if you have, let's do some dates here. If you filed for bankruptcy 2 years ago, right, that you cannot file for another 6 years when it comes to Chapter 7, right? But you still have 3 years left on the loan. What are we going to do? If you turn back that car, turn it back in, you're going to get sued. You're going to get sued on the balance of the car. And you cannot file in this hypothetical for another 6 years. Remember, every 8 years, you can file another Chapter 7 if you filed Chapter 7 previously. So with that in mind, that's the problem with reaffirmation agreements. Just understand that you're telling the bank, we're not including this debt in a bankruptcy. And if something happens and you cannot refile for another 8 years and the bank can collect another 2, 3, 4, 5 years, you're going to turn in that car, you're going to get sued, they're going to take that money out of your paycheck, and then ultimately you're going to have to file for bankruptcy again to get rid of that debt. So that is the downside of keeping your car. Again, we can't predict the future, right? I bought a new truck a couple years ago. Everything's going well, but I can't predict what's going to happen, 3 months after I bought that vehicle, or even 3 years later, 5 years later, etc. So it's just part of life, but just keep it in mind that if you did sign a reaffirmation agreement, you cannot reopen basically your bankruptcy case to include it. It's too, or, the clock, we can't turn back the clock of time on there. There's nothing we can do other than try to make the payments, maybe sell it, and make the difference. If you sell it for 10,000 but you owe 12,000, then come up with the extra $2,000 so you can avoid bankruptcy again. Okay. Now, for those of you that already filed bankruptcy, this is always an issue, and it really comes down to this. There's really no other way of saying it. Creditors are on the extreme end of the way bankruptcy law works and the automatic stay. Now, we know from prior posts and videos, the automatic stay is what prevents most lawsuits from going forward, right? So if you're getting sued by a credit card company and you turn around and you file for bankruptcy, that lawsuit is paralyzed, it's frozen until the bankruptcy case is resolved. Problem is when you have certain debt, like let's say car loans and mortgages, secured debt, and you try to make a payment on that debt, well, the creditor won't talk to you, especially if you have a lawyer. Actually, they do even when you don't have a lawyer. It shows you how clueless they are about this. You're trying to make your payment. You're going to keep your car. You already know about the reaffirmation agreement. You know you're going to keep making payments. You're okay. Everything is fine, but you're trying to make a payment and they don't accept it. The first thing they do is they cut off your online access. All of a sudden, you can't go online and say, "What's the balance?" I'm going to go ahead and make a payment today to transfer. That gets cut off. Then you call them and say, "We're not going to talk to you. You filed for bankruptcy." They won't even accept payments over the phone if you tried that before. Some creditors will. Keep that in mind. Try that option if it doesn't work. But why does all this happen? Well, according to creditors, not lawyers, who practice bankruptcy law, just the fact that they talk to you and collect a payment, they're violating the automatic stay and the Fair Debt Collection Practices Act. Are they? No, they are not. They are going to the far extreme end of the way that that law is interpreted when it comes to the automatic stay. But it's going to happen. So when you file for bankruptcy, in case your lawyer doesn't tell you this or you filed without a lawyer, just understand getting them to collect that payment is not going to be easy. What do? Simply mail in the payments. If you want to go old school, write a check or have it dispersed straight from the bank. If you used to do automatic withdrawals, for example, my bank, my two card payments are made automatically. The bank just goes in there, takes out the money, and we're good. If I file for bankruptcy tomorrow, that stops. And then I'm gonna have to, program my online system with the bank to go ahead and send out the checks. Problem with that is you don't realize it, right? You're dealing with a million things: the house, the kids, the home, sports, school, etc. And then all of a sudden you realize I'm 30 days late on my payment, maybe even spent that money not realizing that the bank didn't take out the money. So be very careful with that. You have to, for a while, we're going to be balancing checkbooks. We just can't go online and say what the balance is to decide how much we can spend this month, because once you file for bankruptcy, again, they're not going to be accepting payments. And once that happens, you're going to be in a situation where you might fall behind and you don't want to go there. So once you file for bankruptcy, if the creditor won't talk to you, or they will talk to you but won't take payments over the phone, then the answer is make sure that payment gets sent out by mail so you can keep your car, no issues with your home, etc. Okay, so that wraps up how we deal with the issues of the car. Now, like always, if you want to ask me a question that I can respond to personally and post it in the readers question forum, or I set it up as a blog, send me an email. All right, I've already written several blogs on questions that I've received from the readers. Thank you for continuing to read the blog. Thank you for keep coming back. I just started this a few months ago, but it's looking good. I like the way the blog is looking. So if you don't like the way it's looking, send me an email and say, hey, change this or change that. Okay. So, but be nice to me. Come on, I deserve it. Now, if you're a paralegal or you're taking paralegal courses or you're also a legal study student, remember you have my textbook that's available through all major retailers. It was published by Routledge Publishing, which is a major academic publisher. You can get it pretty much anywhere, any major book retailers, including Amazon. You can just go online and send it, and they'll send it to your house. We all love those Amazon packages, don't we? Now, to wrap things up, find me on Twitter. Let's start talking via Twitter if you want. You can also find me on Facebook. Remember, you can always even send me the email if you have a questions you want to post on the readers question forum. Likewise, if you have a question about today's blog, you can put it in the post in the comments section, some of the issues that you may be having. but now you know the issue. If you file for bankruptcy, the creditor is probably not going to talk to you. If you have a lawyer, they'll talk to the lawyer. That's typical, right? But just make sure you don't fall too far behind on those payments, because the creditor is going to stop withdrawing it. And this includes everything. This includes your car payment, and this includes your mortgage. All your other expenses stay the same, right? Utilities, cell phone, none of that is going to change, but it will change with your mortgage and your car payment. All right. So take care, everybody. I'm going to keep posting videos this week, and any questions, reach out to me or go to the blog and start looking for the answers to your questions. I've got a lot of blog posts up in the last few months. So I'll see you then, and I'll see you to the next video, everybody. Take care, have a good week, and be safe.